How's the sound back there for the press? Good? Good volume? Well, good morning. It's good to see a lot of you, a lot of familiar faces here. I'm Darcy Olson. I'm the president of the Goldwater Institute, and it is wonderful to welcome back some of our longtime friends and to see some new folks in our audience today, and of course to welcome the press for whom we have created this special event today. There's quite a bit to go through, and I want to move through it pretty quickly for them. We've promised them an in and out in about an hour's time, and we plan to stick to that. So, without further ado, let me tell you how we came to where we are today. About 4 years ago, this summer, I was in the middle of taking the 30 hours of training that are required in Arizona to become a foster parent. And in one of those classes, a slide went up, and it said something to this effect. All of these constitutional protections and processes that we've been teaching you about will apply to any child who comes into your care, except for Native American children. And I was sure that I misunderstood that slide. That didn't make any sense to me, that there would be different sets of rules for children based on their race. That just seemed to conflict with everything that I understood about the U.S. Constitution and the rights and protections that it affords to us under law. So the next morning, I did what anybody would do. I stopped in my colleague Clint Bolick's office, because he knows everything there is to know about the Constitution, and I said, last night there was this slide, and it didn't make any sense to me, and can you just kind of clarify what this federal law is doing? Can it really be depriving Native American children of the basic constitutional protections that are afforded to all of the other children in America because of their race? And that conversation with Clint 4 years ago is what brought us to this press conference today. Clint will be speaking to you today. He is our Vice President for Litigation, and he has successfully litigated multiple cases, constitutional cases, before the U.S. Supreme Court. The issue, the racial issues and barriers to adoption is actually, this is not a new issue for Clint. He challenged race-based barriers to adoption in the 1990s. And in that case, it resulted in the enactment of a federal law that forbids discrimination in adoption in all cases except for Native American children. Also speaking today will be Dr. William Allen, who is the former chairman of the U.S. Commission on Civil Rights. Dr. Allen is also a founding member of the Coalition for the Protection of Indian Children and Families. And he began advocating for Indian children in 1989 when he learned about a Native American teenage girl that had been taken away from her adoptive family and placed on her birth mother's reservation without her consent and despite her pleas to stay with the only family she had ever known. And he has been fighting for change and for these Native American children ever since. Today we are also releasing an in-depth investigative report by Mark Flatten, who is an award-winning investigative reporter, and he happens to be our chief national investigative reporter here at the Goldwater Institute. Mark's investigation, which is available for all of you on the internet and here today, exposes the consequences of what we believe is a well-intentioned law but very ill-conceived law. It tells the stories of children who have been repeatedly returned to abusive homes to face beatings and incest, rape, neglect, and in some cases, death. This is all because they are Indians with fewer rights and protections than all other children in this country. We've produced a 9-minute video to accompany this investigation. And directly following this video, you'll hear briefly from Clint Bolick and Dr. Allen, and along with Mark Flatten, they will be glad to answer any questions you may have.
Indian Child Welfare Act originated at the request of the Spirit Lake, then Devil's Lake Reservation. The motivation that was cited was to protect children from improper placement in non-Indian foster homes by local public authorities. Unfortunately, that was solving a problem that had existed a generation earlier and was already fading from view in the 1970s. It was no longer truly the problem. The main problem facing Indian children and Indian families was trying to find suitable family situations for children who were too often abandoned or too often abused. And the law completely neglected and overlooked that dimension of the problem, which means that not only has it not obtained its objectives, it's actually made the situation worse. It's often compelled children to be placed in dangerous situations in which children have been greatly harmed. We see this today, of course, at Spirit Lake. We have had children placed in homes where predictable deaths have followed. The White Shield case is just one of many of those. We could name others also.
Hope had taken the kids and threw them down an embankment. Both kids got thrown down the rock embankment. After Hope pushed them both down the embankment, and the older kids were told not to say a word, and she was going to be fine. She just bumped her head. And they took them back to the house, and Lauren never regained consciousness. She bathed them, both girls, and Lauren was still unconscious at this point. Bathed them, put them into bed together, and the next morning, Michaela woke up, but Lauren obviously didn't. When they interviewed Hope, Hope just said it was too much for her. She couldn't handle them, and she needed a break.
We have essentially abandoned Indian children to fairly fast and loose procedures on tribes and at the hands of tribal courts, which are not interested in responding to the question, what is the best interest of the child, but is rather interested in responding to the question, what is the best interest of the tribe. What is at stake here is the identification of the tribe as a cultural entity deserving to be preserved at all costs, and therefore by accepting out the ordinary protections of law and constitutional rights for American citizens. The Indian child is therefore a pawn in terms of maintaining the enrollment numbers of the Indian tribe and maintaining what becomes ultimately a facade of culture rather than a reality of culture.
I believe in ICWA. I believe that any child that is Native should have the opportunity to know his or her culture. I'm aware of how our own people abuse ICWA. We all need to be held accountable for what we do. The community centers to make the children aware of the sex offenders that live within our reservation. It has all our sex offenders, what level they're at, and then their picture. We have an extravagant amount of sex offenders living within our reservation. There was anger that people like me spoke out. We were liars. We were condemned as we didn't have any allegiance to our reservation because of what we had done. I wanted to make a difference. I wanted to make it better. This is my home, but not everybody feels the way I do.
They often use the words, our children are sacred and we need to protect them, but I don't see it happening. They're sacred. If they were sacred, like the powers that want to have the recognition, they wouldn't be put in homes of abusers. They wouldn't be taken from a nurturing foster home just because they're non-native and brought back into this cesspool of alcohol and abuse. I'm not sure why they're placing them in homes of perpetrators, but they will not speak up because they know that it means their death sentence. There's nothing true about sovereignty here. I mean, if it were truly sovereign, we would be doing a lot of our cultural activities. We would be practicing child care, lack of violence towards adults as well as children. We would be doing that if we truly were a sovereign nation. We're not. We're hiding behind the word in order to keep the power.
So when we now, a generation later, find that we are routinely placing children in homes in which there are violent sex offenders, in homes in which the drug abuse is rampant, in which neglect is more of the commonly the occurrence than otherwise, it is certainly to be remarked as ironic is almost too soft a term to use, tragic that we allowed such rationales to produce the situation that we face today.
We first filed the application through the tribe to adopt Lauren. The ICWA representative for that tribe asked if we could adopt her. She was impressed with everything we had, our credentials, our background, our dedication to our community and to kids.
You know, I was there just like her birth mom, and I fed her in the middle of the night. So it's immediate. It's immediate. You know, she was our child by then.
The tribe changed their mind and decided that they wanted to fight this process, that they weren't going to approve of the birth mother's choice, and felt that they should have first right of refusal on the child. Now, for months and months previous to the birth of the child, the tribe had never presented a potential family for the birth mother to choose. They didn't have one. Nobody wanted the child. What puzzled me about the ICWA law itself and the concept around ICWA was that in the case that you have a healthy birth mother who is making a choice to where she feels is best for her child, that somebody can interfere with that and say, we're sorry, you're wrong. And we're gonna take it no matter what you want done, regardless of what you feel is best for your child. It seems insane on the surface, it really does.
For me, I would lay in bed at night and, you know, everything's going through your mind. You know, we have a court case coming up, or we have a visit from a social worker. Is it gonna go our way? And I pray, God, do not give me anything more than I can't handle, which would mean her being taken from us.
The tribe had a casino, and they had unlimited funds at their disposal. For us as a family, I think the total bill in the end of it, about $300,000 at a time when the market was crashing. It ran us into bankruptcy. There's no way around it. They brought in psychologists from both sides that had done assessments of the child. Both psychologists said this will be detrimental to this child to pull this child out of this family 3 years later. But in the end, the tribe said, we're done, let's settle.
I knew that here she would have lots of opportunities. I didn't know if she was taken away, what her opportunities and what her life was going to be like. So that was scary for me because I'm her mom at that point. And so the unknown for her, if she were taken away, is just, you know, she's in a good place. I think it needs to be dealt with on an individual basis, and best interest of the child every single time needs to be, where is that child going to be taken care of the most? And that's first and foremost, every single time.
As children requiring protection, they're being looked at as pawns in the interest of preserving and protecting tribal status, so that we don't find any usual recourse to judgments about the conduct, the habits, the attitudes of the homes into which children are placed, since the only thing we're initially concerned with is to identify an Indian family, even if the connection is remote. The individual really has no say on this at all.
Good morning. I am Clint Bolick, Vice President for Litigation at the Goldwater Institute. It is a pleasure to join all of you, including my old friend Bill Allen, and the courageous families who are joining with us to announce a legal challenge to a systemic injustice that affects thousands of families and innocent children all across the United States. As Darcy mentioned, 20 years ago, I was lead counsel in a Texas lawsuit representing a couple named Scott and Luann Mullen, whose household, bursting with natural, adopted, and foster children, resembled a mini United Nations. But there was always room for one more, and more than enough love to go around. One day, the Mullins brought in an infant named Matthew, who in the womb was addicted to crack cocaine and infected with syphilis. They nursed this little boy to health, and as with so many foster families, they fell in love with him and wanted to make Matthew part of their family. But instead of facilitating the adoption, state social workers wrenched Matthew from the only home he had ever known for one reason. Matthew is black, while Scott, who is white, and Luann Mullen, who ironically is Native American, are not. It is hard to believe that as recently as the 1990s, many states were erecting barriers to interracial adoption of black children. Those who sustained the barriers referred to interracial adoption as cultural genocide. Fortunately, rational thinking and the best interests of children prevailed. Congress passed a law forbidding racial discrimination in adoptions. Matthew was reunited with the Mullins, where he and his brother Joseph became a permanent part of the family and grew up to be fine young men. Sorry, perhaps I'm not speaking closely enough. I thought the problem was solved, that the pernicious practice of racial discrimination in adoption placements was consigned, like other Jim Crow laws, to the dustbin of history. And indeed it has been for all American children except Native American children. Not only for full-blooded Native American children, but even for those with a tiny fraction of Indian blood sufficient for a tribe to claim them as their own. Not only for children who live on reservations, but even for those who have never set foot on a reservation. And not only in the context of adoption opportunities, but even for removal from dangerous and abusive families. Such children are not accorded the rights of other American citizens, but instead are subjected to a separate and profoundly unequal law, the Indian Child Welfare Act. A law born of good intentions but misguided in its provisions, often destructive, and as the video by my colleague Mark Flatten you have just seen reveals, sometimes even fatal in its consequences. In Arizona, every child has the right to removal from a home where there are reasonable grounds to believe that protective custody will protect the child from suffering abuse or neglect. Every child, that is, except a child deemed to be Native American. In Arizona, every child is entitled to a determination that a foster placement is in his or her best interests. Every child, that is, except a child deemed to be Native American. In Arizona, every child is entitled to the full constitutional rights of equal protection and due process of law. Every child, that is, except a child deemed to be Native American. In all of these respects, Arizona is a microcosm of the entire nation, whose state child welfare laws centered on the best interests of the child are forcibly displaced and commandeered by a federal law that subjects Native American children to adverse treatment solely because of their race. It is thus an appropriate venue for a lawsuit testing the constitutionality of that law, a lawsuit we announced today. The Goldwater Institute's Sharf Norton Center for Constitutional Litigation, consistent with its core mission of protecting individual rights against government abuse, has filed a class action lawsuit representing two families whose efforts to adopt their non-reservation foster children whose blood quantum may subject them to tribal jurisdiction have been jeopardized by the Indian Child Welfare Act. We represent as well the children whose best interests are threatened by the federal law. In turn, they seek to represent the interests of a proposed class of similarly situated prospective adoptive parents and non-reservation children. We are joined in this lawsuit by the distinguished Washington, D.C. firm of Cooper and Kirk. The defendants are Kevin Washburn, Assistant Secretary of the U.S. Bureau of Indian Affairs, which enforces the federal law, Secretary of the Interior Sally Jewell, and Arizona Department of Child Safety Director Greg McKay, who administers the state laws that implement the federal law. We have filed the lawsuit in U.S. District Court in Phoenix. Our lawsuit has 6 claims. First, that by classifying children and those who seek to provide them with permanent loving homes, not as individuals but by their race, the law violates the constitutional guarantee of equal protection under law. Second, by subordinating the best interest of children to the professed interest of tribes, the law violates the constitutional guarantee of due process of law. Third, that by displacing and commandeering state law, the federal law violates constitutional principles of federalism, as articulated by Justice Clarence Thomas in his concurring opinion in the recent Baby Veronica case. Fourth, that by forcing non-reservation children with a quantum of Native American blood and few, if any, contacts with a tribe into tribal association and jurisdiction, the federal law violates the children's First Amendment freedom of association. Fifth, that the Arizona state laws implementing the federal law violate 14th Amendment guarantees of equal protection and due process. And finally, that recently issued Bureau of Indian Affairs guidelines that implement the Indian Child Welfare Act in a particularly draconian fashion exceed the agency's authority under federal law. 2 years ago, thank you, 2 years ago, the U.S. Supreme Court addressed the Indian Child Welfare Act in the Baby Veronica case. The opening words of that decision exemplify the law's perversity. And I quote, "This case is about a little girl who is classified as an Indian because she is 1.2% Cherokee. Because baby girl is classified in this way, the South Carolina Supreme Court held that certain provisions of the Federal Indian Child Welfare Act of 1978 required her to be taken at the age of 27 months from the only parent she had ever known and handed over to her biological father, who had attempted to relinquish his parental rights and who had no prior contact with the child. Though the court majority acknowledged that such an interpretation would raise equal protection concerns, it narrowly construed the law to avoid such a harsh effect. But in so doing, it left fully intact the law to the detriment of many other Native American children. By filing a proposed class action encompassing the full range of perverse consequences visited upon Indian children by federal law, we hope to establish once and for all that Indian children cannot be subjected to separate and unequal treatment. These children are human beings. These children are American citizens. These children deserve the same rights as other American children. If a child surrenders her rights based on the racial composition of her blood, then we really have not gone very far in vindicating the ideals upon which this nation was based. If there ever was a context in which those rights must be protected, it is where a vulnerable and innocent child is consigned to an abusive home, or more hopefully, where she encounters an opportunity for a fulfilled and happy future. In either case, her race should not matter, must not matter, not one bit. To the parents and children who stand with us today, and the many others whose interests they represent, My colleagues and I and the many people who are supporting us make this pledge. We will do everything in our power to make sure that this story has a happy ending. Thank you very much for being with us today.
Good morning. I'm William Allen. My role here this morning is to be the exclamation point at the end of the sentence. You get to the end of the sentence and you look around and you ask, what are you doing there? And the exclamation point responds, I just rushed in with the excitement. Well, that's the whole story. This is not a new story, it is an old story. There has been injustice in the land, and the injustice has been visited upon nameless and faceless Indian children. Families that love those Indian children, and indeed our society at large that has tolerated this injustice. There's one single point I want to make clear. It has been referenced already, and that is that the idea that you can determine the best interest of a particular child through legislation or regulation without even noticing who the child is utterly insane. Every determination of best interest for a child must be a decision made in equity. It must be a decision made case by case, on the facts of the case, taking into account who the people are and what are the circumstances in which they live. And it cannot be disposed of by a racial paintbrush. So, I'm delighted that this case has been taken up by the Goldwater Institute, and that they are not only filing in the names of those parents and children who are their immediate plaintiffs, but they're filing in the names of all parents and children, including those who either provide foster care or adoptive care for children who are not deemed to be Indians, because you may not realize this, but one of the consequences of the Indian Child Welfare Act in our society today is that there are many people who don't adopt at all for fear of being trapped in the web of the Indian Child Welfare Act, or of those who do proceed who spend inordinate time seeking children to adopt, though there are many children at need, because they want to avoid coming into contact with the Indian Child Welfare Act. This piece of special legislation designed to satisfy a special interest has proved to produce general devastation throughout our society. So it's extremely important that this case has been filed. It's extremely important that we are paying attention to it. It's extremely important that we finally reach the day where we recognize a great mistake was made in 1978 when Congress adopted the Indian Child Welfare Act. And that great mistake lay in the fact that Congress imagined itself to be doing a service for Indian tribes without ever pausing to reflect it was doing a disservice to the United States of America, and especially to those American citizens who are Indians. For once they accepted the offer of American citizenship that was extended in 1924, they became blood of the blood and bone of the bone of all who benefit from the guarantees of freedom in this society, not to be set apart and distinguished from any of the rest of us. Congress forgot that because Congress acted under the false assumption that it had plenary authority, not over tribes alone, but over the individuals in those tribes. And so here is a word to Congress and a word to the courts. In the United States, no government has plenary authority over any individual. We have rights that are designed to prevent that. And we have a Constitution that is designed to enforce those rights. And no one today deserves to have those rights enforced vigorously more than those American citizens of Indian descent. So I applaud you, Clint, Darcy, and I thank you, and I trust that this will move ahead speedily with good success, which encourages me, therefore, to say, Godspeed.
So we have Dr. Allen, we have Clint Bullock and Mark Flatten here to take your questions. And if you would be so kind as to raise your hand, I will call on you once everybody is seated and ready to go. Howie?
Got somebody else's microphone, which is cool. I guess I'm struck by one particular thing here today. I look around your audience, I look at the Goldwater Institute, and I don't notice a lot of Native faces here. Where was the outreach to Intertribal Council, to other Native groups? Because right now, what I see is a lot of, excuse the expression, well-meaning gringos saying, we're here to represent the best interests of Native Americans. Where are the tribes on this? What outreach have you done to that, and why aren't they part of this?
I can start in working on the story, which, by the way, if you look online, the documentation of the story is extensively web-linked. I attempted to contact 7 or 8 of the largest tribes, the tribes that are most active in ICWA cases. They won't talk to me, with the exception, ironically, of the chairwoman at Spirit Lake Indian Reservation. So tribes do not particularly want to talk about this. They tend to make their arguments in court. They tend not to discuss it with the media. I would certainly encourage you, Howie, and anybody else in the media to attempt to contact the tribes to get their position. We did do a significant amount of outreach to not only to the tribes, but to Native American organizations, to pro-ICWA groups, to the attorneys that represented the Cherokee Nation and Dustin Brown in the Baby Veronica case. So we have done a great deal of outreach. You may have noticed on the video that we talked to several tribal members up at Spirit Lake who have raised concerns about children being placed in the homes of registered sex offenders, which was a fairly commonplace practice up there. If you want a real eye-opener, Google the term New York Times, Spirit Lake, Santa, and you'll find a very horrifying story about what was going on up there. We talked to the tribal elder, Joanne Streifel, who made the point that you can't just dismiss this as sort of a cultural difference, because child abuse and child molestation is not part of the Indian culture. So we need to discern what is protecting the culture and what is protecting the abusers. That was a point that she stressed very strongly. We talked to Molly McDonald, a former tribal judge up there, that raised concerns about Indian children under this law being placed in tribal homes purely because they were a tribal placement, not looking at the backgrounds of the people that they were being placed with. There's no better example than Lauren Whiteshield. She was raised for 2 years by a minister in Bismarck, North Dakota. Her and her twin sister, they were doing very well. They were happy, playful, loving children. the tribe determined that it wanted to take these girls back to the reservation. They took them back, and a month later, Lauren is dead, thrown down an embankment by Hope Whiteshield, the grandfather's wife, who had an extensive history of child abuse involving her own children in tribal court. None of that mattered. What mattered was the child was being placed back on the reservation. So we did do a significant amount of outreach to tribal communities, to tribal leaders, to tribal organizations, and to pro-ICWA groups. That's probably a little more long-winded than you were looking for.
Add, very briefly to that, of course, our class, our proposed class will include children who are subject to the Indian Child Welfare Act. If you had 20 of them here, you might not recognize them as Indian children. You might or might not. We use the term because that's the term used in the law, but as in the baby Veronica case, that child was 1.2% Native American. One of the perversities in this law, at least in the old Jim Crow laws, the state defined what constituted a black person. Under this law, the Indian tribes determine who is subject to the jurisdiction of law. I'm aware of no other law in the country that allows an entity to determine who is subject to its own jurisdiction based on blood quantum that that entity sets. This is a relic of a bygone era, and we need to change these laws so that people are treated as individuals, and we do represent their best interests.
Charles.
To what extent does the, thank you, to what extent does the current composition of the ICWA law have a tendency to, conceal may not be the word, but make the victims less apparent to the rest of society because of the way the law is structured in terms of the jurisdictional aspect of it?
It's really, actually, no one except for a full-blooded Native American would even realize that they were necessarily subject to the Indian Child Welfare Act. Basically, all you need is for one parent to be a registered member of a tribe and the child to be eligible for membership in the tribe. Tribal eligibility is determined by the tribe, and therefore, basically, as Darcy has explained the process here in Arizona, you're asked whether you know of any Indian heritage that your child may have, and as soon as the answer to the question is yes, then this web, as Dr. Ellen has described it, can be cast upon you.
In the back? Is it?
I just can't resist pointing out that the story of Elizabeth Warren tells us with great clarity that anyone who speaks up about recognizing people from their faces to be American Indian or not is speaking falsely or with forked tongue.
Hi. As I understand it, the current process with the State Child Welfare Agency is when they get calls of abuse and neglect, the ones pertaining to tribal children are screened out and sent to the tribes. How would this litigation affect that process? And as a follow-up, we all know DCS is pretty swamped already. Do you really want to send these children into a system that isn't quite fixed?
I'm not sure that they do just go to the tribes. I think it's everybody gets the call, or at least in my experience in my agency and several other parents I've talked to, you know, families have gotten newborns from the hospital, so it may be that the notice goes to the tribes at the same time that it's going to all the agencies. That would be my understanding. Okay, and as far as the implications?
Basically, if ICWA were struck down, the provisions that we are challenging are struck down, then the state child welfare laws applicable to every other child would apply to children with Indian heritage as well. And so you would have the presumption of best interests of the child in any type of placement, you would have the protections that apply to children that allow them to be removed from abusive homes and so on and so forth. And that's exactly what we think is appropriate.
There might be, instead of removal, preventive moves. Would this pertain to those as well? Who would have jurisdiction over that?
The state would have jurisdiction over that for non-reservation children.
Yeah, I was just going to further amplify that all of these cases end up going through Child Protective Services or whatever the state agency's name happens to be. The only difference is that in cases that are identified as affecting children of Indian descent, they have to notify the tribes that the process is underway and may have to defer to decision-making in the tribes. And it's important for us to remember that it's not only infant and young children who get caught up in these snares, but status offenders, juveniles, adolescents who have to go through juvenile court systems, if they are determined to be of Indian descent, also are subject, because of ICWA, to these kinds of determinations, so that you cannot simply send them off into various forms of diversion without first making a check of cultural reference to determine what the appropriate diversion is for this particular person, if the person happens to be of Indian descent. So it's not as if there is a large field of cases out there being untended by state agencies. All of them are tended by state agencies, but they're tended in such a way as to require them to defer to the tribal jurisdictions where appropriate.
Sure.
You know, not to get too deep into the weeds, but typically what will happen is, let's say you have CPS respond or DCS respond to a child abuse call. They will go into a home in normal circumstances. They'll look at whether there is ultimately evidence, strong evidence that that child will face continued danger if it's in the home. The stuff with Indian heritage gets sorted out later. Given the fact there's no blood quantum requirement, there's no requirement they ever have lived on a reservation, there's no requirement that the family have any significant contact with the tribes. In many of these cases, they don't actually discover an Indian heritage until this process has already begun, and you're well into the process of child protection. So what you have, one of the ways the law tends to keep kids in abusive homes is if you have a parent who is clearly abusing their children and threatens their health and safety. If it's a non-Indian child, then the state has to come in and prove through clear and convincing evidence that leaving that child in the home is a danger and is likely to result in serious physical or emotional injury. If it's a Native American child, the state has to come in and prove beyond a reasonable doubt that leaving the child in the home will result in serious harm. That's the same standard that's used in a criminal case. So the state essentially, to remove a child, an endangered child from a home like that, has to prove that this parent is going to commit a crime that hasn't been committed yet. That's just one of, so if you read the investigative report, you'll see case after case where you've got an abused child who is in a home that the state moved in, the state did the procedures to remove that child, and under normal state laws, that child would have been removed and placed in a safe environment. But because of the heightened standards of ICWA, the child was repeatedly returned to the home. In the case of Declan Stewart, a little boy out of Oklahoma, he was beaten to death a month later. In the case of a little girl named Shayla in Nebraska and her sister, she was repeatedly returned to the home of her father, even after everybody knew or even after allegations of child molestation had arisen. So because of this law, where you would have a normal state procedure with a non-Indian child, that it would be pretty clear that there's sufficient evidence to remove this child, there is not sufficient evidence under ICWA because of that higher standard of proof.
In the front, Marion.
Warren's case, is it a DNA sampling? Are we talking minuscule numbers? 2, is there a financial benefit to the tribes to increase the membership? And 3, what makes you think that Child Protective Services is a shining light on a hill?
First, it is, there is occasionally DNA testing performed on children to determine blood quantum. I don't know in Elizabeth Warren's case whether that was done or not. Secondly, I can't remember what the second question was. Oh, financial interest? I'm going to defer that to, do you know the answer to that?
I can speak to it.
Okay.
Not definitively. I don't want to name this or that particular tribe as having been engaged in rent seeking. Nevertheless, it is true that much of the effort to boost enrollments has informed claims of Indian descent in these cases of fostering or pre-adoptive adoptive proceedings, so that we know that the tribes have an interest in it, not because of an interest in the children, but because of an interest in their status under federal regulations and their entitlements that flow from that status.
And on the third question, DCS is a shining star. It certainly has not been. But the major difference is the rights to which the children are entitled in one system as opposed to the other. And as Mark just articulated, that can literally be a matter of life and death in many instances with the different standards and rights that apply.
Just one side note, there's not a fixed blood quantum in the law. So if you have a heritage tracing to the Cherokees, they have no blood quantum requirement. So you can literally be 0.0% Cherokee, Native American blood, and if you meet the other requirements of tribal membership, you can still be considered a Cherokee. The Navajo tribe has, I believe, a 1/4 blood quantum requirement. Some tribes have 1/2 blood quantum. Some tribes require a certain percentage of blood quantum to that particular tribe. So it's completely all over the board, and the way the law is written, the tribes get to define for themselves what the qualifications for membership are. So if the Cherokees don't want to have a blood quantum requirement, that means they can claim a little girl like baby Veronica because of her 1.2%, whereas Veronica would never qualify for membership in most other tribes like the Navajos. So it's just all over the board.
In the back?
Is it not true that the American Indian is the only minority group that has a sovereign nation status? That may be the genesis of all of this problem?
At the moment, we think that is an accurate statement in terms of sovereign nation. The law is justified under the Indian commerce provision of the Constitution, and this is not commerce. These are human beings. These children are American citizens. So the question is, do they shed their constitutional rights when a tribe determines that they are subject to the tribe's jurisdiction?
Any more questions?
Mark, you had mentioned the tribes like to make their arguments in court. Oh, Mark, you had mentioned that the tribes like to make their arguments in court. What are some of the arguments they've made in court?
Well, one of the arguments that the tribes made, particularly in the Baby Veronica case, and it was actually joined by a number of other organizations, including the Arizona Attorney General's office, is that state courts really aren't equipped to determine who's, quote, Indian enough. So one of the arguments they make is it's a bad idea to have state judges try to determine, okay, what is a sufficient blood quantum to be considered a Native American? What is the significant or significant connection with the tribal culture to be considered a Native American? Tribes are very concerned about that. Tribes also make the argument, based on a previous Supreme Court case, that this is not about race, that it's about political status, that they're free to set their membership requirements. All ICWA says is basically to be considered an Indian child, you either have to be a tribal member or eligible for tribal membership, and the child of a tribal member, I believe, is the language. but you got to remember that you don't have, mom and dad don't have to be tribal members when you're born to have you fall under the jurisdiction of ICWA. If you read the investigative story, you'll see a number of cases in which the parent joined the tribe after the child custody case had already begun. So there was no pre-existing connection to the tribe in any way. Tribes also invoke the sovereignty argument that we are sovereign entities similar to states, and we just have the right to do this. So, but and then the other argument that they sometimes will make is that, well, in the first half of the 20th century, Native American children were removed from reservations, and so now there are not that many Native American children still living on reservations. So you kind of depleted our population pool, and now you're saying that they have to live there. So there are a variety of arguments, but most of them, the central argument that they're all built around is that ICWA is not based on race, that it's based on political affiliation, and that's using code language from a previous Supreme Court case.
Everything that Mark says is true. I would add, though, that the single most insistent argument the tribes make is that the regulations of the Bureau of Indian Affairs implementing the law, ICWA, requires the states to defer to the tribes. Their legal argument turns on that more than anything else, that this is a matter of simply following the regulations.
Charles?
I know if you remember a history of advertising, there was a ad for an anti-pollution ad a number of years ago in the late 60s where they had the fellow of Native American heritage paddling a canoe down a polluted river and a tear coming down his eye. That guy was known as Iron Eyes Cody, but he had no Indian blood. He was actually an Italian, a fairly dark-complected Italian, but who was an actor and had played in the movies many parts portraying an Indian. And eventually he was so convincing at it that a northern New York tribe actually granted him membership. Now, I didn't say this to be funny. My question is under that status, if he had a child, would that child be covered under ICWA because he was a member of the tribe?
If the child was eligible for membership under the tribe's guidelines, the answer would be yes. And if getting back to a point that Mark made about one of the arguments that the tribes are making, that state courts are in a bad position to determine tribal membership eligibility based on blood quantum. We agree with that argument. We think that government should get out of that business of determining rights based on someone's blood quantum altogether.
How are we on time? Close to 10? 2 minutes, okay. We've got time for one more question, if anybody's got one. In the back, please.
Thank you. The idea of this sovereign nation, that's a relatively new thing in the history of the United States. I think it's been about 30 years that it started, and there's never been any such thing as a sovereign nation. They're wards of the government, the tribe is, and they've just perpetrated this myth, and it's very discouraging that it has been so generally accepted.
Certainly, I don't mind pointing out that the language goes back more than 30 years, but let us say it comes into currency with peculiar emphasis in the 1970s. And it is part and parcel of the whole new federalism initiative that was launched by President Nixon, and which the tribes received quite eagerly at the time. Because there was somehow imagined under this concept of new federalism or self-government for the tribes that there would be an arrangement or a relationship between the tribes and the federal government that would leave them out of the direct command or supervision of state sovereigns. Because we've always referred to our states as sovereign, even though we regard them as dual sovereigns, that there is split sovereignty in the United States. So the term itself is not a new term and not newly applied. It is only the awkwardness of applying it to reservations, which now number several hundred and sometimes are large and sometimes are hardly noticeable, and trying to make sense out of what that kind of degree of independence that would bring them. That's the problem we confront today. So I wouldn't focus so much on the word sovereignty as on the legal background, and whether we go all the way back to Talton v. Mays and late 19th century court decision, or we focus on the new federalism of the Nixon era. It's going to be a political problem, first and foremost, and trying to place in perspective what those political interests are that have led to this insistence.
There is an entire body of law relating to jurisdiction, and it generally refers to the minimum contacts that are necessary to establish jurisdiction in a particular entity. That's thrown out the window with ICWA. I was born in New Jersey. I have no doubt that the Garden State would love to lay claim to a share of my income if it could. I do have New Jersey blood running through my veins, but I no longer have minimum contacts with that state to allow it to do so. And okay, I'll work on that. But the notion that a tribe can assert jurisdiction over the life and liberty of an individual has never set foot on that reservation, and who has no desire to be associated with that community, it turns the Constitution on its head.
I'd like to thank all of our supporters who are here today who make it possible for us to take on this fight. And our special thanks to Mark Flatten and Clint Bolick and Dr. Allen for their terrific work on this issue. To all of the reporters who came today, our panel will be available after for private questions if you'd like, or on-camera interviews. So with that, we'll thank you for coming today and see you next time.